We're live.
Hello to all of you. My name is Aziz Saliba. I'm a professor of international law at the Federal University of Minas Gerais, Brazil, and the president of the Brazilian branch of the International Law Association. If you are interested in international law, please subscribe to our channel and consider joining our association. Einstein used to say that there are questions that only children can ask, but that once asked shed new light on our perplexities. Our distinguished guest tonight, or this morning, if you are in Australia, Professor Anthea Roberts, has formulated one of those simple yet fascinating questions. Is international law international? In other words, is international law a universal language? Is it understood and applied in the same manner worldwide? In addition to posing this question, Professor Roberts has written a sound response with plenty of data and analysis. Such response is the book, Is International Law International?, which won numerous prizes, including the American Society of International Law Book Prize, and was Oxford University Press's top-selling law monograph worldwide in 2017 and 2018. It is certainly one of the most relevant contemporary readings for anyone interested in international law. Professor Anthea Roberts teaches at Australian National University, and before joining ANU, Professor Roberts taught at the London School of Economics, Columbia Law School, and Harvard Law School. We also have with us Professor Michele Ratton Sanchez from FGV, São Paulo, and Professor Lucas Lima, my colleague at the Federal University of Minas Gerais. Both are members of the board of directors of the Brazilian branch of the ILA. They will try to help me provide a Brazilian reaction to Professor Roberts' work. Professor Anthea Roberts, it's a pleasure to have you with us this evening or this morning, and you have the floor now.
Am I mine?
Yeah.
Yes. You've got sound? It said it was muted. Okay. Well, thank you very much for the invitation. I would love to be with you in person, but hopefully sometime when the coronavirus pandemic is subsided, that will be possible. I've got great affection for Brazil. I've actually been working hard on a new book, so I've been deliberately saying no to all invitations to present this last book, but I particularly wanted to come and do this one because I'm particularly interested to hear about kind of a Brazilian approach to these issues. Brazil was not one of the countries that I focused on in this study, but it's obviously a very important and significant and growing in importance and significance in the world. And so I'm very keen to hear the perspective of it. And one reason that I like to present this in different countries is I'm acutely aware that both my own journey as a scholar, but also the readers' journeys are very influenced by how they're situated within the system, and that what's obvious in one context or obvious from one perspective is not obvious from another perspective. And so sort of being aware of that kind of background I find really helpful. So let me share my screen now, and I will just start with a PowerPoint on this. Great. So this book, as the introduction said, is about whether international law is international. And it really came to me from a sort of a play on the traditional question that we're used to asking, which is international law law? And instead of asking that question, which seemed to grace the beginnings of every law course that I either sat in as a student or gave as a professor, I started to ask the question, is international law international? Because I realized that we're used to the idea of comparative domestic law, comparative tort law, comparative contract law, comparative constitutional law, because we work on an assumption that domestic legal systems are different in a way that might be meaningful to compare and contrast across countries. Whereas as I started to move around from different academies, I started to realize that international law, which I'd assumed was not something you could study comparatively, did actually seem to be different in the different countries that I studied in and worked in. And that struck me as particularly interesting because I was moving, as you could tell from the introduction, between three Western English-speaking common law countries, Australia, the US, and the UK. And I thought to myself, if I start to notice some real differences between these communities, how different might international law look from the perspective of those in China, or from the perspective of those in Russia, or from the perspective of those somewhere in Africa or in Latin America? And it was really through doing this study that I started to sort of break apart my own personal experience with the field, which is that it was one that very strongly claimed to universality, and that was sort of inherent in the idea of the international. And yet, what I came up again, time and again, once I started looking for it, was that there were patterns of difference, that I was seeing different communities of international lawyers in different states doing different things and focused on different ways and having different reactions. That despite these differences, I also saw very clear patterns of dominance of some of the traditional approaches, or some of the regional or country approaches, having a very strong claim to being the international approach in a way that they were often not as self-conscious of on the inside, but was very apparent to those on the outside. But that this was also likely to come under challenge, and that I thought we were entering into a period where we were going to see significant disruption in terms of all sorts of geopolitical power distributions, economic flows of students. And this was going to require us to think in a much more careful way about different approaches and having dialogue between them. And so one of the analogies I used to kind of explain what I found was to think about international law that is it really is a language analogy. So to what extent is international law really like multilingualism, where we have different languages with different communities of speakers speaking about potentially the same thing, but in different ways, and we don't know how similar it is, and we don't know how different it is? Or is it something like English as the lingua franca, which is that there is one approach that was originally one of the local approaches that has come to define the dominance of a certain approach on the international stage as though it were international, but really is sort of a reflection of the hegemony of a particular area, but one that may be losing in power at the moment. And so it was these sort of ideas of difference and dominance and disruption that sort of came through this particular study. Now, when I chose to study it, there are many, many ways you could study this, but I was particularly interested in the community of international lawyers. And so one of the things I did was I picked, you can't study all states, so I picked the 5 permanent members of the UN Security Council, because they are states that have always been accorded a particular priority in the international system. And they also represent a very kind of interesting group of states with some commonalities, but some real diversity. So you have some of the democratic versus non-democratic. You had some of the sort of Western European and others grouping versus not. You had language differences of English versus not, common law versus civil law, etc. And so they were an interesting kind of case study in and of themselves. But I also partly picked them, and this was going back 5 or 6 years now, on a sense that the geopolitics was going to be coming strongly back into the international system, and that some of the fractures that we saw within the Security Council were going to mimic some of the fractures we were going to see more generally. And I think some of that has really turned out to be true. But as with any collection of states, you obviously have real blind spots when you do this. And so, for example, there's no representative state from Africa in my study, but the same is true for Latin America, which is one of the reasons why I strongly wanted to present on this today for Brazil. Having picked which states I wanted to look at, I also needed to look at the sort of communities of international lawyers. And it's very hard, for example, to look at the communities of government international lawyers. It's hard to get access to who they are, what their backgrounds are, what they write, what they think. Whereas it's much easier to be able to compare and contrast international law academics who are in different states. And so I found this to be a sort of a way into the communities of international lawyers in different states that I could both access and understand, but also use as evidence for some of the differences that I was seeing. Doesn't mean it's perfect, but it gives you some sense of the differences. And I looked at academics and its textbooks because I was interested in communities of international lawyers, but I was also interested in the way in which we present what international law is. And through our textbooks, that's how we sort of teach our next generation of international lawyers. It's a subsidiary source of international law, but it's also not meant to be an argumentative account. It's generally meant to be sort of a bread and butter account of what is in the field. So with this in mind, let me just give you three tasters of some of what I find in this particular study. I'm going to tell you a little bit about comparing international lawyers themselves, a little bit about what happened when I started testing the textbooks from the different countries, and finally I'm going to have some reflections of what this means for the competitive world order that I think we can all see ourselves in today. So let me start with the Invisible College of International Lawyers. So Oscar Schachter is famous for saying that we are all part of an invisible college of international lawyers who are dispersed throughout the world, yet engaged in a continuous process of communication and collaboration. And this is an image that we as international lawyers, who are often very sort of cosmopolitan-minded, tend to really like about ourselves, that we're part of this worldwide invisible college. And yet, as I started to move between different countries, I started to become aware that international lawyers in different countries often had very distinct educational profiles based on where they had studied and where they taught, and very distinct publication placements, not just by language, but also by country, that meant that you created these very different communities of international lawyers, some of whom spoke very clearly to each other and others who completely missed each other. And one of the good examples, I would say, of this were the debates over the what happened in Crimea with Russia. That what I saw there was one debate about this in some of the Western outlets, and another debate entirely in some of the Russian outlets over whether or not this was an annexation of Crimea that was a violation of the use of force, or whether or not this was the reunification of Crimea and its right to self-determination, its reunification with the mother country of Russia. And what I started to see here was these incredibly different communities of international lawyers who were both writing about the same subject, but had very different assumptions about the law and understandings of the facts that meant that they were really living in parallel universes. But also there was almost no communication between these two groups of international lawyers. They didn't reference each other almost at all. They didn't engage with each other almost at all. And some of that started to make sense to me when I looked at these educational profiles and publication backgrounds, that I found, for example, that the Russian international lawyers, most of them had done their first law degree in Russia, their second law degree in Russia, their third law degree in Russia, and they published about 98% of their materials that I could find in the Russian language in Russian journals. And there were all sorts of incentives as to why that was the case, but it meant that they created a very distinct Russian international law debate, which was quite different to the Western ones, where we saw many of the Western scholars had only studied in the West, only published in the West, and that also reflected their incentives. So I started to notice education and publication as being something that divided us within the college. But I also started to notice very different connections to practice and incentives in the different colleges that divided us in different ways. So I was writing in the US at the time, and I could see that many of my colleagues there had done law school in the US, then worked for US federal and Supreme Court judges, worked for the US government, and then came in and published in US generalist law journals. And they were very connected to kind of a US foreign relations law approach to international law, which was quite different to what I saw, for example, in the LSE, where I'd come up originally, where many of the international lawyers had not only come from outside of the United Kingdom, but they never worked for the UK government. They didn't do UK foreign relations law, but they were very, very sort of linked into international courts and tribunals practice. And if you see, for example, you go to International Court of Justice representations, not only has it largely been by Western states, these are the academics, but very strongly by the duopoly of the UK and France. And this was something that meant that you actually ended up with a very different community of international lawyers in the US and the UK, two core English-speaking states, where the US one was much more of a foreign relations law understanding of international law, and the UK one was much more of an international courts and tribunals understanding of international law. And this differed again from what I saw, for example, in the Chinese situation, where you didn't see such a strong attachment, for example, to international courts and tribunals, but you saw a very, very strong emphasis on international economic law. And so one of the ways I evidenced this sort of encouragement was through Chinese research funding, which tended to call for international economic law topics and law of the sea topics, particularly after the South China Sea incident, and fund these to a much higher degree. And this sort of shaped the community of international lawyers you saw coming out of China to end up being quite different from their counterparts in some of the other states. So I started to see different communities of international lawyers, but then I asked myself, well, how does this translate into what they actually teach international law to be? It may be that we're in our different countries, but that we're all teaching the same thing. But as I moved across from the UK Academy into the US Academy, I remember needing to teach international law to the 1Ls at Harvard. And I set an American casebook because I thought, well, it's all international law, but they'll be used to the case-based method that you find in the American law schools. And as I stood in front of the class that semester teaching these international law cases, I had this profound feeling of this isn't the international law that I know. And that was because a huge number of the cases were actually by US domestic courts, particularly the Supreme Court, that struck me as not being the kind of oracle of international law, but in many cases also struck me as not actually being a particularly good student of international law. And also struck me as just extremely American. And so I started to think to myself, well, is that the case? Is it just that this is highly domesticated? Or am I just noticing this because I'm not from this particular country and maybe you just don't see it when it's your own textbooks? So I started to ask myself the question in the textbooks I looked at, what percentage, for example, of the cases that they cite to come from international courts and tribunals, which is in blue, from their own domestic cases, which is in red, and from foreign domestic cases, which is in green. And this just gives you a sample here to show that actually my reaction to the US textbooks, it was not just in my mind, that they did actually have a much higher proportion of US domestic cases than you find in many other countries. And particularly the comparison here with China is quite striking. That I think in the US, it was sort of 65 or 70% of the cases were from its domestic courts, whereas from China, none of the cases were from its domestic courts. And you go over across to France, a very strong reference to the international courts and tribunals, like in the previous slide I showed you with the strong association between the UK and French international lawyers and the ICJ. Also a decent number of French cases, but frankly, almost no other countries existed in those textbooks in terms of cases. And so you started to see these very different patterns of how nationalized or denationalized these casebooks were, but they often also imbued like a certain understanding implicitly. So I felt like the understanding implicitly in the US textbooks was international law is what we do, whereas the Chinese textbooks held it much more at arm's length, and international law seemed to be international law is what others do. It sort of happens out there, but not in our home academy. And you may think this could just be kind of string citations or all the rest, but actually when you start to break it down, what you actually see is that they have these quite different emphases. So this is a word cloud of all of the cases that were used in one of the main UK international law books. And I've done it by size, by how many pages the particular case appears on. And as you can see here, in line with those UK international law academics, almost all of these cases are by international courts and tribunals. I think the one big exception here would be the Pinochet case. And after that, you've got Jones in Saudi Arabia. And then after that, almost all of the domestic cases are very small because it's the international courts and tribunals that take precedence. By contrast, if you look at one of the US international textbooks, and this is one of the most foreign relations law ones, the largest case you can see, Sosa and Alvarez-Machain, is one of the US foreign relations law cases from the US Supreme Court. But many of the other cases you can see here, Sementar, Filatiga, Hamdi, are all very much in that same US foreign relations law style by US courts and tribunals. And the one main exception, this Nicaragua in the US case, which was common to both of them, if you think of international law as having kind of a vertical dimension of foreign relations law into a state and a horizontal dimension of international law between states, Nicaragua versus US sits at that intersection of the vertical and the horizontal and appears in both types of books, but also probably gives you a very different impression. If you're used to looking at this version of international law and then you study US and Nicaragua, often the impression is that international courts and tribunals work relatively well, and yet in some of these cases you have a sort of a scoundrel-like state like the US that refuses to accept the jurisdiction of the court. Whereas if you look at it from this perspective, what you see is that most of the time if international law is done, it's done in domestic courts, and that those few times when you try and take it to the international law level, well, it doesn't work. And so international law doesn't have any efficacy anyway. But the next question I wanted to ask myself is not just of how nationalised or denationalised this was, but how regionally skewed was it? And this is something that should come as no surprise to some of the people in Latin America, which is quite nationally, regionally skewed. So I wanted to ask myself, for example, if you looked at all of the UN regional groupings, what percentage of the cases that we had in these textbooks came from the yellow here, which is the Western Europe and others? And I say this advisedly because I know that there are contested definitions about what the West means. And I know in Latin America often considers themselves to be part of the West. But in this particular study, what I want to do is do it by the UN geopolitical regional groupings, because I wanted to ask kind of just of this narrower understanding of the West, how many of the cases came from this narrower understanding? So the question is, how yellow are our textbooks on this? And the answer is extremely. So, for example, the French textbooks, 99.6% of the cases came just from this narrower group of Western states, 99% in the US, 96% in the UK. But it wasn't just that all of these Western European and other states in this grouping were equal. What I saw time and time again was a basic duopoly of here you're going to see US cases are marked in yellow, UK cases are marked in blue, and for the most part, many of these states had this real duopoly of US and UK filtering out into these case books. And so we saw not just the dominance of the Western regions, but this very strong Anglo-American dominance, which is something that I'm sure is quite clear when you come not just from outside the West, but also from another language-speaking area. But I didn't just see differences in the cases that were presented. I also saw some quite clear differences in substance. So, for example, one of the biggest topics that I found in the Russian international law textbooks was the law of outer space, which I found quite interesting at the time because in my textbooks, it either wasn't there or was given a very small amount of space. Whereas in the Russian textbooks, not only did it often have its own chapter, but it often had the same amount of space as something which I considered to be core to international law was trade and investment law. And so what I started to see is a very kind of different perspective on kind of what were the core topics of international law and how much space do you give them. But I also saw very different opinions on some of what were the hottest topics in international law. And so again, in Russia, I found, for example, one of the strongest topics that got some of the most heated debates was about whether the individual could be a subject of international law. And this was not something I saw nearly as heavily debated in my Western textbooks. But I started to realize that it was actually a bit of a proxy battle between some of those that hewed much more strongly to the Soviet Union traditions that were very sort of state-oriented and that states are the real keepers of international law. And some of those scholars who are starting to tend much more in a westward direction and starting to think about things like individual human rights and the individual as a subject of international law. So I saw very different debates, but often realized they were sort of proxy debates for underneath things that were going on in these academies. I also saw strikingly different views on things like unilateral humanitarian intervention. So I had been used to teaching from my international law textbooks that unilateral humanitarian intervention prior to Kosovo was not lawful, but with Kosovo might have been legitimate and there might have been an emerging trend in favour of this. That is very clearly not what I found. Obviously in the Russian international law textbooks that spoke about NATO's aggression, that it was a clear violation of the UN Charter. But also I thought a very interesting contrast with China, where the Russians would come straight out and say, this is a violation of international law, and those NATO war criminals did this and this and this. And one of them even suggested that Milosevic had died at the ICTY because he'd been deprived of essential medicines. Whereas the Chinese ones would talk about so-called humanitarian intervention and would talk about sort of hegemony and the importance of state sovereignty, but in a much more kind of subtle and understated way, never coming straight out with a full frontal attack, which I thought was also an interesting approach. But it shouldn't be thought that the differences that I was looking at were simply differences between some of the Western and non-Western states that I identified of the 5 permanent members, because you also saw quite clear differences from within the West. And I think one of the best examples of this was the Iraq War from 2003. So in some of the US cases materials books I found, for example, you had, detailed pages and pages and pages where you would have all the different arguments that were put forward in terms of the Iraq 2003 invasion, but you would also have in a very detailed way all the Security Council resolutions put forward and the revivalist argument, so you could see kind of how it was made. And quite often what I would do is set this up as a debate using these materials in my class, and students would often really split on, at the end of the day, whether or not it was lawful or it wasn't lawful, and they would really get into this revivalist argument and sort of go over the minutiae of it. Whereas I would go across to my French international law textbooks, they would typically have one page, occasionally two. It would be under something like a heading of like unlawful violation of the Charter, and it would just say there was no lawful justification, flat, sort of no need for further questions. And so it again creates quite a different impression about whether something is an open or shut violation of international law, which was certainly the opinion, I think, of France, or whether it was something that was sort of open to contestation, which is something that I would say the US and the UK were strongly behind. But what was interesting to me is how much of this often got sort of encoded into what we taught through our materials and the way in which we presented them. Which brought me to the third element that I wanted to present on today, which was this idea of disruption, because a lot of this book is not just about the field that we have found ourselves in to date, but what it might look like going forward. And that was because I think that I had sort of grown up in the 1990s and the 2000s as an international lawyer, as somebody who was used to being in a world that was after the Cold War and that had been an era of unipolar power. And what I started to think was that as we moved past this unipolar power moment towards greater multipolarity, we were likely to see much more contestation in a much more visible way about the meaning of international law. And I started to realize that even my draw to comparative international law, which had not really been part of the core of what I had understood or taught as a student and as a teacher until that point in time, had a very strong presence back in the Cold War when we had bipolar power and people were used to talking about Western approaches to international law and Soviet approaches, but a lot of that have fallen away in the post-Cold War era of the unipolar moment. You saw it in other ways, for example, in the Third World approaches to international law being a very strong critique on the hegemony of the Western approaches and the US and UK approaches, but you didn't see it as a rival power base in the same sort of way as what I think you're starting to see happen now. And that's what I think we're starting to see in this competitive world order, that as we move towards a multipolar world where you've got different states in competition with each other for that global power that have very different views of international law, you're likely to see a much more conscious fracturing of the international power and international legal system. And I think some of the current examples that I focus on in the book were, for example, the fracture between Western approaches and Russian and Chinese approaches on cybersecurity, and whether or not you thought of the internet as a global commons or something that you would have balkanized sovereignty over. You see a very different approach, and obviously since the book has come out, that's become a much more significant issue. But not only do you see these differences of approach on the substance, but you also see them playing out in terms of the sources we use. So in those sort of debates, you very strongly saw the Russian and the Chinese approach being a strong state sovereignty approach, not just for balkanized sovereignty, but that this should also be governed by interstate treaties. Whereas you saw in the US style approach, not just a much more this is the global commons, but also we should have non-binding governance, there should be NGOs at the table, members from industry at the table, a very kind of different conception of how it is you do international law going forward. I didn't just see it obviously in cybersecurity, you also saw it in other areas. So for example, the very, very distinct differences that you could see of some of the Chinese international law scholars speaking about the South China Sea and some of the Western scholars speaking about the South China Sea. They often had a very, very different emphasis on the narratives about who was the aggressor and who was the victim, and how much you focused on whether or not there was jurisdiction in the first place, or if not, that the tribunal asserted it had jurisdiction, so you just had to accept it. You often found quite different emphases in terms of how the situation was understood and communicated, like you had with the Crimea case. But here you actually saw quite a different engagement, which is that unlike the Russian international lawyers, the Chinese international lawyers had often done their first law degree in China, but then they did their second or third law degrees in the West, had at that point been incentivized to write in English, publish in Western journals. And so that is actually what they did, but it created this asymmetrical exchange where they often published out into the West in a way that the Western scholars didn't publish into China. And that was partly because of very strong censorship issues in China on this question, but also the Western scholars did not have the Chinese language skills and were not incentivized to publish in that academy. And so that's also sort of an interesting one to ask the question about how do we have a worldwide dialogue when not only we have different training and different backgrounds, but some countries have a more free academia than others. Where did this take me to in the end? I guess it made me, as somebody who was sort of an English-speaking Western common lawyer who had been in these core states, much more conscious of the importance of seeing through the eyes of others, and much more conscious of the importance of trying to diversify perspectives, diversify sources, and diversify networks. And this is something that I would expect to be much clearer to those who have constantly been asked to see through the eyes of others, either from because they come from a sort of a more peripheral state within the world economy, or they are used to being forced to cross disciplinary boundaries, cross national boundaries, or cross language boundaries. And so this is something, again, where I think that your own situation, your own background really makes a difference. But often when you come from some of these semi-peripheral states or some of these other ones, you often have pressures to cross into, for example, English to present in law. So you get a much better understanding, for example, of US and UK approaches, but you often don't have nearly as much understanding of those things that are happening kind of sideways to you and what's happening, for example, in Africa, or what's happening, for example, in Asia if you're in Latin America. So I think there's a broader call for us to diversify our perspectives, our sources and networks, and also to recognize that we don't need to agree with everything that we read or agree with everything that we hear from different communities, but it's important to understand these different approaches, not only to understand what other communities are thinking and seeing, but also it becomes a very good way of reflecting the mirror back on yourself to understand what some of the blind spots and biases might be in your own approach. So what I might do at the moment is stop sharing my screen there and open it up for questions, because I'm very interested to hear from my colleagues in Brazil about their approaches on these issues.
Well, thank you very, very much for the excellent presentation. It's always a pleasure to discuss your fascinating book. Please allow me now to share with you some preliminary data that we have gathered in an effort to provide a Brazilian perspective on this discussion that you have initiated worldwide. Let me see if I can do it properly here. Okay. Share. I hope you can see my screen.
Not yet.
So is it okay now? Let me your entire screen. Oops, there is a... I apologize, there is some... Let me try again.
I think it's coming.
Okay. Oh,
great.
Excellent. Well, first of all, it's no surprise for those of you who have read Professor Robert's book that we receive in Brazil a fairly small amount of international students compared to the countries in the Permanent 5 group. Our students tend to go to Argentina, US, Portugal, Australia, and France. Those are the top 5 destinations. You can see here the top 20 destinations in this slide. And they tend to come from Angola, this appears also in the book, but also from Colombia, from Peru, from Paraguay, and from Japan. Those are the top 5 origins of foreign students in Brazil in both undergraduate and graduate degrees. Another issue is that we have a huge number of law schools here. However, there is one important detail. An evening or morning class in the same law school tend to be counted separately for administrative matters. But even so, more than 1,500 classes, which is the number that you can see here in the last bar, the number from 2018, is an awful lot. And in all these schools, international law content is mandatory. However, with such gigantic numbers, subjects to be studied, quantity of credit hours, and academic quality varies considerably. So we have decided to take a peek at the top 10 law schools in Brazil, according to a very popular ranking by the Brazilian newspaper Folha de São Paulo. And in this slide, you see the most common subjects that appear, the hottest subjects that appear in the syllabi we obtained. The next slide shows the most adopted international law books. The first 2 are Ascioli, which was a former diplomat. This book has been updated by 2 different people. The latest version was updated by Professor Paulo Borba Casella from the University of São Paulo. And the other one is the book by Professor Francisco Rezeki, who has been a judge at the International Court of Justice. The second most popular book is Amaral Jr., who is also a professor at the University of São Paulo, a course on public international law. And in third, we have a book from 1995, Celso de Albuquerque Melo, and to our surprise, the updated version of Brownlee. These we looked at the cases that are cited in both in the top 2 books. These are the cases that are most cited in Ascioli. And you can see here that construction of a wall on the occupied Palestinian territory cited a number of times, but also French nuclear tests, Aya de la Torre, Shores Factory, La Grande, North Continental Shelf, Barcelona Traction, and other cases. We used blue for cases from international courts and red for cases from domestic courts. And these are the cases that are most cited in Judge Rezek's book. Also, reparation for injuries, the Bernadotte case, Aya de la Torre, La Grande, Southwest Africa, among others. And now this is the percentage of domestic, international, and foreign cases cited in 3 Brazilian textbooks. In blue, you can see the international cases. In red, you can see the foreign cases. And in yellow, you can see domestic cases. If we judge by the number of attendees in the summer courses of the Hague Academy, international law is a huge success in Brazil because we have the highest number of attendees for almost 15 years since I've been counting this. We are ahead of France, Italy, China, India, Iran, and the US. But this comes from a survey by Marcel Kamiyama. He conducted a survey at 4 main law schools in São Paulo. And the question was, considering your career aims, do you regard public international law as relevant for your professional future? And there were two possible answers. Answer A was yes, and answer B was no. And he divided them into two groups. Group A were students who had not taken international law yet, and Group B, students who had already taken international law. You can notice that the number of people that found that international law was relevant for the professional future actually decreased after taking the course. So I would like to end this first part, Professor Anthea Roberts, with a short provocation. In your view, what is the role of the student's perception about the professional relevance of international law? And on how such discipline is taught in law school, what's the relevance of what's the role of the student's perception about the professional relevance of international law, and how such students' perception can impact the visible College of International Law?
You want me to reply now?
Yeah, please. And then I will hand it to Professor Michel, and after to Professor Lucas, and then I will finish with some questions that I have received here.
Okay. Well, first of all, thank you so much for doing that study on Brazil. I'm totally delighted to see that. And I look forward to seeing if you send it to me or write it up. I would love to put that out on Twitter because I think it's so interesting to see that. The textbooks that you talk about, also the Crawford one is very interesting because I think one thing we do see is such a strong sort of movement of the UK international law textbooks, but now to also see them going more into Latin America where they have not traditionally had such a stronghold is also a really interesting thing to see. I think one of the things that's particularly interesting also in Latin America is you looked at sort of case citations, which obviously I had partly done because of my common law training, but one thing that became really clear to me is that was also not the best way to understand some of the civil law systems that I was seeing, and it made me much more conscious that when you pick a metric that you're used to from certain legal training like case law, you can it can be not a way to understand some countries and can kind of render them less relevant on that metric. China being a very good example of this as both non-Western but a civil law country, where China obviously does a lot in international law but not through its domestic courts. So if you make domestic courts part of your metric for understanding international law, you see an awful lot of the US, you see an awful lot of Israel too, but you don't see much of China. So I think these things just make you more conscious of that. On your question about the relevance, so this is one of the pushbacks that I got in the US Academy, which was this strong sense that, well, students need this to be relevant to their profession and therefore it needs to be US foreign relations law because that's what they're most likely to encounter. And curiously, I didn't get that kind of response in the UK. So let me just say at the outset, for me, this is not a normative question that one approach is right and one approach is wrong. I'm much more interested in macro framing to understand what's similar and what's different and why it's come about and what it might mean. So it's not that one approach is correct and the other approach is not. What it's clear to me in a context like the US is there's sort of more hostility generally to international law, and so the international lawyers there, I think, are often placed in a defensive position where they're having to justify their relevance. And one of the ways that they justify their relevance is to try and tie it more closely to practice, and that's part of also why they move to US foreign relations law as opposed to, lofty namby-pamby international courts and tribunals. I guess what's interesting to me is in the UK international law context, you just don't have that same inherent hostility from the domestic students, but also you don't have that same hostility from the international students. And so they don't have that same kind of need to justify and to tie it to domestic practice. And to me, that's probably the more interesting thing, that you get these sort of differences of kind of what's accepted in the room. And I like to just surface those differences as something that's important. I think that there are very different arguments about what you understand university teaching to be, and particularly in law, which can sometimes be a graduate and professional degree, some people see it as being much more tied to practice, and some people see it as being much more kind of as almost a discipline or giving you broad understandings of the fields. I think, to me, with international law, a key part of international law is making you aware of other approaches, and so getting outside of your national context is a very important part of that, because if you're going to be in any international negotiations or any sort of multinational business, that sort of consciousness that what you're used to dealing with is what you're used to dealing with, but is not universal, to me is a fundamental lesson, and one that you miss if you tie it too closely to the domestic practice of your state. But if you don't tie it at all to the domestic practice of your state, you can also give the impression that it's completely irrelevant. And this is something I saw very strongly with some of the Indian approaches, where there was no Indian international law textbook. Nothing on the domestic market. It all came from their former colonial master, UK. And so it gave the impression that international law not only happened in international courts and tribunals and in the British courts, but really didn't have a buy-in at home. And that struck me as a real shame, because obviously these issues are crucial in India. India's taken a very different approach to the UK on a number of international law questions, but also India has a rich tradition of things like third world approaches to international law, which you would imagine would be more strongly articulated in an Indian international law textbook than they are in the UK international law textbook. So I think you want to sort of do some stuff to locate it in the domestic, particularly when students ask for that. But sometimes you also want to give students things that they don't know that they need. And part of what I think people often don't know that they need is that they have certain blinders that they're not even aware of because of the way that they've grown up. And I think international law can also serve that purpose.
Thank you very much for your reaction. I'll now ask Michele for her comments and questions.
Okay. So good evening to all. Good morning, Anthea. It's an enormous pleasure for me to join this book discussion in the ILO Brazil webinar series. I thank Professor Aziz Saliba here representing our branch in Brazil for organizing it. Professor Anthea Roberts, it's an honor to discuss your award-winning book with the Brazilian audience. It's also a pleasure to share the discussion position with my colleague, Professor Lucas Lima. Most of my shared thoughts today are part of a collaborative work about the book with Professor Morosini and the Brazilian diplomat Henrique Moraes, with whom I'm writing a review of Anthea's book. We hope to have it published soon. For the students' audience, as Professor Aziz already highlighted, I highly recommend the reading of the book, as this book accounts to the question that most of us may have posed to ourselves and the beginning of an introductory course about international public law. The perplexity before reading the materials, the court proceedings and decisions soon alert us as students in the Global South that international law is driven by the dominant powers, usually northern countries, in terms of format and content. The patterns of geoeconomic dominance at play alert us that international law is an established institution to coordinate states globally with other international law agents. It is not a universal but universalized tool. Although critical perspectives on international law have elucidated that understanding, it did not reach the core of the discipline, and your book did. So here is the first great merit of this book. Thank you, Anthea. The methodology of the book in contrasting data about global flow of students, educational profiles, publication, and connection of academy and practice, as well as of textbooks and casebooks, give us support to the main takeaway from the book. The idea that international law narratives, rather than an expression of universally accepted concepts and rules, are in fact the internationalization of the particular view of a number of actors that exert oversized influence in their field. Anchored on a rich empirical work, Professor Anthea Roberts' book provides us a detailed analysis of how that game is played internationally. It is a unique book providing a better awareness of the field. In our review of the book, though, we raised the question, to what extent is international law comparatively international in Brazil. The Western influence, as Professor Aziz has showed, is noticeable in Brazil in the flow of the students, of the Brazilian students and ideas, and the publication placements. However, in analyzing the connections of academia and practice and the role of textbooks, we see singularities in Brazil challenging the methodology, as if we would have a divisible college inside one country. The first is the fact that the academic careers have not mobilized people to move around different regions in Brazil in the law field. Therefore, we see a degree of regionalization of international law in the country. I would suggest that the textbooks that Professor Aziz just showed us are more often applied in certain regions than in other regions of the country. Second, international competition in the scientific mode of production in the last years has favored a recent split of academic scientific production from other instructive technical books and their epistemological communities. The academia in one side and what we could say as the civil servants on the other side. In Brazil, to accede to the public service, the executive and the legislative technical supports and the judiciary position, one might take entrance at examinations, highly influenced by textbooks prepared for such exams. They are not only prepared for law schools, they are prepared for the exams, the national exams. So we can say that textbooks have an important role to the practice of non-diplomatic public service more than other careers on international law. Finally, the diplomatic career and its training school, relevant actors in the Brazilian engagement with international law, has had its own dynamic and circulation of ideas and influence, as Lucas will better detail to us today. Apart from testing the comparative model of your book in Brazil, I would like to hear from you about other challenges to that agenda. Although you had China in your comparative data set, how would you explore the impact of Chinese perceptions of international law to the world today? Applying the language of winners and losers of the 21st century, what is the West losing in its sphere of influence? How do you see that happening? And where? Where do we locate the recent dominant trends for international legal order from your point of view? Those are my questions for you today. Thank you so much for being with us.
Thank you. So again, thank you for the richness of your application of this in the Brazilian context. I mean, that is just a beautiful breakdown of some of the differences. I'm going to be really excited to read this. I should also say that I think you and your co-author Fabio have been really quite remarkable speakers from some of the Latin American approaches and some of the Brazilian approaches and some of the approaches from the South in your work. And I wanted to say, just as a shout out, how much I've appreciated that, but also how much I've appreciated you not just speaking about your region into some of the global debates, but also looking sideways. And I know that you're now doing work on China and Latin America and stuff. I think that there's something very kind of unusual and marked in your 360-degree orientation about where you look and also where you speak to, which I think is just unusual and something I really appreciate in your work and your work with your co-authors. So where is this for China at the moment? So basically, I had in my background, two different parts of my background. I had the sort of international trade and investment law, so international economic law, and then I had public international law, which became increasingly interesting through this in sort of geopolitical change and the effect of that. And this book finished, and those two worlds I thought were about to collide. And I think what we've seen in the last couple of years is those two worlds have indeed collided. And so we're seeing that really strongly play out in the trade and investment regimes and in the WTO. And we're seeing in that area, I think, the strength of both the US and China, meaning that it's very, very difficult to get international agreement on the rules of the game when there are new issues or on adjudication. So I think this is an example of the sort of fracturing that we saw in my book, where I focused on like areas like cybersecurity and the South China Sea, we are seeing move out into other areas that had been less fractured, like trade law. But I think a lot of the focus in the writing at the moment is on like the US and China, that sort of dyad. But I think in the next couple of years, much of the focus will go to not just their competition with each other, but how their competition with each other is playing out in third markets. So how it's playing out in Latin America, how it's playing out in Africa. And so I think one of the interesting things is going to be sort of seeing how we get kind of what I'm thinking of as a variegated globalism, where we get different kinds of splintering on different kinds of issues and different kinds of groupings, and how that plays out. So you can imagine regional groupings, but you could also imagine like groupings of Five Eyes, groupings of democratic states, groupings of Western states, all sorts of different groupings that may or may not sort of congregate around certain issues. And so you're clearly seeing, I think, in some of the states in the Five Eyes breaking on issues like Huawei, and I think you're going to see that in Europe. But how does that play out in Brazil and Latin America? How does that play out in Africa? I think we're going to see some very different patterns happening in different parts of the world. So yeah, that's strongly part of my research agenda in the next 5 years, and I think it's also part of your research agenda, and I look forward to reading what you find on this as well. I should also say, though, I think that both the US and China have not been doing themselves a service recently. I think if you want to take kind of an inclusive approach that says others come with us, that we are sort of maybe more hegemonic but benign hegemonic, I think both the US and China have been doing things recently that don't serve that goal and have been making other states increasingly wary of both of them. But given that they are both major providers of all sorts of things, it's going to be hard to see how third states navigate that. But I think sort of Trump's America and some of the wolf diplomacy that we've seen out of China has been disadvantageous to both powers.
Thank you, Professor Roberts. We'll now have our second and thank you very much, Michele, for the excellent comments and questions. We'll now have our second discussant, Professor Lucas Lima, my colleague at UFMG.
I think Professor Lucas had a problem. He's not showing up here anymore. I'll check if he can reconnect. Okay.
While Professor Lim comes back to our discussion, I will take this opportunity to ask one question, one of the questions that I have here for Professor Anthea Roberts. The question is that in your book, you talk about patterns of dominance and dominance, difference, and disruption. How do you think the COVID crisis will impact the disruption?
Sure. So I think that the COVID crisis, most people are characterizing as an accelerant on lots of different tensions that were already there. So I think in terms of US-China hostility, it acted as more of an accelerant. You could imagine a world in which you say, look, we've had these geoeconomic differences, but when it comes to global threats, let's all come together and fight it in a united way. That's not what we saw. We saw much more squabbling and much more sort of pointing of blame. And I think it's exacerbated the tensions. And I think that's also going to play out in future elections. We're going to see much more kind of criticism of China from some of the players in places like the United States. I think we've also seen China feel more confident about its own approach in handling the coronavirus situation. I think that the very draconian way that they first cracked down on it, I think many around the world looked at with horror, and many of those same people around the world are now looking in horror at the US's failure to crack down on it, and the failure to crack down in some other countries. And so I think it's going to have implications for people's understanding of different models of governance. Of course, that's not just China. There are a range of states that have done better and worse, and they across Western, non-Western, democratic, non-democratic. So I don't think there's a unifying principle there, but I think we'll see increased debates on it. I think one of the things I think that's going to be particularly interesting is it's going to have moved a lot more of our life online, and anything that moves online, and with this in the fourth industrial revolution, turns us into higher producers of data. And I think we're going to see much more of a bifurcation of the internet, 5G and technology in coming years, which will be exacerbated by how deeply technology is embedded in our lives. So I think that will also act as an accelerant. But I think in many ways that the implications I've seen so far from COVID have been more strongly on the domestic front. You're seeing some states that have existing fractures within their social fabric, existing socio-economic inequality, poor access to healthcare, poor domestic governance records, that those are making an enormous difference at the moment in ways that are sort of destabilizing countries and also making it harder for them to act on the international stage. So I think it's going to take a few more years before we kind of work out what the international impact of this is going to be. But it certainly has not been the hopeful impact of coming together in a crisis that you may have wanted.
Very unfortunately, yeah. I have to agree with you on that.
Yeah.
Now, Professor Lucas Lima is back. So, Professor Lima, I hope you stay with us and you'll have the floor.
Thank you very much. You see, perhaps international law is not so universal, but technical problems are, and they happen everywhere in the world in this kind of lives. So let me be quick. Thank you very much, Professor Aziz Saliba. Thank you for the International Law Organization, Brazilian branch, for organizing this. It's for me a great honor to share this online panel with you, Professor Roberts, Professor Sanchez Badin, and also Professor Saliba, three academics whose work I admire really much, very, very much. It's quite challenging to speak after Professor Sanchez Badin's accurate analysis of Brazilian academic field, and even more difficult to offer a meaningful reaction to the precise data offered by Aziz Saliba. I will nonetheless endeavor to offer the viewpoint of a scholar that has recently entered the national service as a professor adjunto and now is trying to struggle with the Brazilian academic system and adopting these two handbooks that Professor Aziz showed us in the beginning of his presentation. Using some of the lenses that Professor Robert in her book offer, I would like to formulate some questions about our own national tradition. It's needless to stress how interesting Professor Roberts' book is, but perhaps I just should have highlighted the fact that this book invites reactions. It invites the reader to think about and reflect upon its own national experience and its own national international law tradition. I'd like to start with a phrase that is attributed to Tom Jobim, which is, Brazil is not for beginners. O Brasil não é para principiantes. I suspect that Tom Jobim did not have international lawyers in his mind when he devised this maxim, but to some extent, I believe that it applies to our field, especially for young scholars. A good illustration might be the fact that the first Brazilian textbook, published in 1851 by Pedro Altran da Mata Albuquerque, was actually a translation of the famous Droit des gens modernes de l'Europe, written by the German international lawyer Johann Ludwig Gruber. As the Brazilian professor Ayrton Ribeiro shows us in his research about the book, entitled Elemento de Direito das Gentes, without a reference to Europe in the title, the book is substantially an ipsis literis reproduction without reference to the European counterpart, with one exception. While Kluber's book condemned slavery, that part is missing in our first Brazilian textbook. At the time, significant part of our workforce and economy was based and came from slavery. And it's difficult to draw definite conclusions from this fact, but it offers us a glimpse in a trend that we can identify in other experiences and which appears translucidly in Professor Roberts' book, The Infrequent Closeness of Scholarship with Power, National Interest, Foreign Policy and Politics. These elements, of course, might lead us to explore a number of other interesting questions regarding our academics. For instance, what are the subjects Brazilian international lawyers prefer to study? Where do we mainly publish our work nowadays and in the past? The focus on regional topics such as Mercosur or the Inter-American Court of Human Rights can be perceived as an abstention of engaging in a more universal subjects. The close link between public and private international law in our universities has to an extent influenced a Brazilian approach or perception about international law. Just to offer you an example, an important shaper of the Brazilian approach or Brazilian tradition of international law was Clovis Bevilacqua, a professor of private law who was the legal advisor of the Minister of Foreign Affairs. Time is running and I cannot enter all these topics, but I would like to focus now my short examination in the background of some of the most distinctive international lawyers Brazil had produced, which means judges of international courts and tribunals. Only one of the indicators that can offer us some food for thought in relation to the Brazilian reaction. Looking at the curricula of the last 3 judges of Brazilian nationality elected to the International Court of Justice, one will find that they all have studied abroad. Professor Cansado Trindade in the United Kingdom, Professor Rezek in France and also in the UK, Ambassador Sete Câmara in Canada. The same applies to the Brazilian nationals that went to the appellate body of the World Trade Organization and the International Tribunal for the Law of the Sea. This perhaps proves a certain pattern of dominance described in Professor Roberts' book. At the same time, if we look at the way they do and think about international law, we might find a range of different approaches, from an extreme positivism adherent to Kelsen and a just naturalistic approach inclined to human rights. Something that most of the Brazilian judges have in common, though, is the fact that they have strong connections with the Ministry of Foreign Affairs, formally and informally. The Ministry of Foreign Affairs, or just Itamaraty, is an important factor to understand Brazilian legal foreign policy, or la politique juridique extérieure, to use Guy de la Charrière expression. This is perhaps another layer that we could all add to this scenario precisely depicted by Professor Sanchez Badin and Professor Saliba. One cannot ignore that international law in Brazil has a strong connection with the ministry, and the ministry, as Professor Sanchez Badin said, has its own logics to circulate knowledge. And I can offer just some quick examples. 2 of the Brazilian international law judges were former diplomats. The Brazilian members of the International Law Commission usually come from the Ministry of Foreign Affairs. I believe that all of them came from there. In the last appearances of Brazil before the ICJ in advisory proceedings, Brazilian positions were sustained exclusively by diplomats. One of the textbooks Professor Roberts mentioned in her book, the textbook I studied when I was an undergrad student, Hildebrando Ascioli, Geraldo Nascimento, Professor Aziz showed us today, is a book that dominated the field. Both of them were diplomats. Rezek's book, he was the Minister of Foreign Affairs. Here, one of course can only tentatively offer reasons for this close connection between Itamaraty and international law. However, while the technical qualities of Brazilian diplomats are unimpeachable, not all the ones responsible for influencing and shaping international law produced scientific works that legal academics can engage with. This seems to be a drawback in comparison with the other countries analyzed in Professor Roberts' book, and perhaps we could hear some reaction in this regard. But unfortunately, the contact with Itamaraty is not something that a scholar in a country of continental proportions like Brazil can count on. And I agree with you, Professor Sanchez Badin, we have regional differences even within Brazil. That's something that I identified today, looking at the judges we produced. But one can even say that there are cities or regions more inclined to study international law, but this is another thing that we cannot discuss here right now. Scholars entering the career nowadays might struggle with at least two difficulties. The first one is to find a good position where they can conduct research properly, and two, to establish a dialogue or continue a dialogue with colleagues abroad. And here is one of the most interesting points of the conclusion of Professor Roberts' book, the idea of two communities that one is part of. Brazilian scholars sometimes are quite aware that there is a transnational and an international debate on their topics, but at the same time, they have to respond to a not so reasonable requirements of national agency, the administrative responsibilities in the faculty, the huge amount of teaching, sometimes in disciplines that are not even connected to international law or law, and balance the points of publication that one has to every year to send to the ministry. And to be frank, as a rule, publishing in international journal in English is not something that one is required in their evolution of their career, at least not even in legal disciplines. This is changing, luckily, but these are the rules of the game. So we have to feed national networks. At the end of the day, I have the impression that Brazilian international lawyers are stuck somewhere in the middle of a dilemma that appears in Professor Roberts' book. Perhaps a more lyrical illustration of this dilemma is found in the famous Jorge Amado novel, Dona Flor and Her Two Husbands, where a widow, Dona Flor, is captured between the dilemma of a new, diligent husband and the ghost of her late beloved husband who collapsed in the midst of carnival celebrations. Very Brazilian. The new husband dresses elegantly, is stable, and comes from higher classes from Bahia, with European origins. He is also a little bit boring. I would say that we could call him a gentle civilizer. The late husband is the opposite. Because of its origins, he is chaotic and not so serious as the new one, but extremely charismatic. He is the only one that Dona Flor is used to and is at ease with. Brazilian international lawyer seems quite aware that the new system is better, is concrete, is possible to reach. But it's the new husband. But sometimes it's much more comfortable to engage in the satisfying and aspired system. This is only my perception, someone that still believes that one can have a good career in international law, even coming from a sorry state, to use Professor Chimney's expression that appeared in your book. And I would like to end my intervention asking two questions to Professor Roberts. Perhaps after reading your book, scholars can be more aware of the fact that different national traditions and approaches are our reality. However, once the awareness is achieved, what a scholar from a country like Brazil can or should actually do? Try to engage in the dominant pattern, try to develop a criticism and influence the national institutions and diplomacy of these realities? Should we all embrace a trailer approach by default? I know that you end your book saying that the position of countries like Brazil and India are still to be seen, and in this divisive context that could be even labeled as a tough soccer match with different players, different teams playing in the same field. I'm sorry again for the bad analogy. But my question is not regarding Brazil in general, but Brazilian scholars. One of the paths of the book seems to suggest is we should engage in more comparative international law. And this leads me to the second question. I suspect that you have already answered this question before, but in any case, I think that this is the opportunity to ask you this. If we undermine the potential and the capacity of international law as being the common language of international relations by stressing its dissidence and its fractures and its differences of approaches, what common grounds remain? By engaging in international law and stressing national traditions, aren't we at the end of the day stimulating closeness and the nationalization of the few? Aren't we saying to Dona Flor, stay with your dead husband, because the new one, no one is certainly, it's not so good as it's promised, it's not as international as it should be? I'm sorry for the bad analogies, and I thank you very much for being part of this. I'm very happy to ask you these questions and to react to your wonderful book. Thank you very much.
Thank you so much. Can you hear me now? Great. So I have to say, Aziz, would you mind having one reaction to Professor Lima while I just go and get my power charger, because my computer seems to be losing power much faster than it should be, and I don't want to be cut off. So give me one moment to get the power charger if Aziz has a comment, and then I'll come back. Apologies for this.
Professor Lima, thank you very much for your reaction. I didn't know that you were a fan of Jorge Amado, and
I am.
It's an excellent analogy with Dona Flor. And we will wait for Professor Anthea Roberts. So I ask the audience for their patience. She is right back with us.
Hello. Sorry about that. So lovely to meet you, by the way, and a really wonderful and rich set of comments from you. So one of the things that I really like about Brazil and talking to Brazilians is that it is such a complicated case. And I started one of my articles on the investment treaty system, likening the investment treaty system to a platypus, because it sort of seems stitched together from different ways in a way that wasn't comprehensible. And I've since found out that people refer to Brazil as a platypus, which I find strange given it's an Australian animal. But it does seem to me that Brazil is such an interesting combination of all sorts of things that kind of are unusual, that it's often an exception that proves various rules. And so it's not a surprise to me that you're finding so you've got all sorts of things going on here. You know, you're a big power, you're in Latin America, but you're not Spanish speaking. It's not English speaking, but you're also not Spanish speaking. And you've got the ties to the continental legal traditions, but you've also got an increasing focus on this sort of Americanized Anglo approach. And you've got the BRICS thing going on. And I think it's just such an interesting combination of different approaches. One of the things that's quite marked about what you say is the intern, and this was also from some of the previous commentators, that it's not homogenous with any particular country, and that I think is absolutely right. That I focus in particular on hierarchies between countries, but there are very clearly hierarchies and different regional approaches within countries as well. And you've focused in particular on sort of the regionalization of that and how that can vary in different places and often varies by your proximity to the power of capital. But one of the things that's very clear in some other countries is there's also socioeconomic differences. And so how international law might be perceived or might be taught might be very different at some of the kind of elite schools in some of these countries versus in some of the other places. Whether or not even you have international law can be very different between those things, whether it's a luxury good or something that's essential to your country. And you also see that in different countries around the world. There are some countries that require international law as part of the basic degree and others that would never dream of requiring it to be part of the basic degree. So I think there are all sorts of interesting differences there. One of the things that you comment on particularly is the closeness of the relationship between the Brazilian scholars and the Brazilian Foreign Ministry. So I've never focused so much on the closeness of that relationship in terms of what it does to the Brazilian Academy, though obviously it will have impacts. One of the ways I've focused on that is on what it does to your foreign ministry, because I think your foreign ministry is one of the most intellectually interesting foreign ministries in the world. And you see that in both the intellectual strength and creativity that they bring to their mission, but also I feel like they have a tradition of having their diplomats function a bit more like public intellectuals than what I see in many, many other countries. And so, I mean, one of my co-authors in a paper is a Brazilian foreign ministry official. And he is able to speak about some of these issues in a way that I just don't think you would ever see coming from the State Department or from the Australian government. And I think that's part of a tradition in Brazil of these very strong public intellectual international law types. And I think Brazil's been kind of extraordinarily effective in a number of international environments for that kind of creative approach. So it probably does have an impact on the scholarship, but the impact on the foreign ministry itself is actually, I think, a very, very positive one. What does it mean for scholars that come from Brazil to engage in this? What are your choices? So I sort of feel in many ways I am the least suited to giving advice on this. So I try to stay out of the normative debates about what's good or what's bad or what we should do here, partly because I think we're also situated by our own experiences. Me as an Australian English-speaking person doesn't feel particularly well placed to be giving advice to people from your country and facing these issues. But it's also partly because I think that the approach is intensely personal for individual scholars, and also there isn't a right approach. In some ways, we need different scholars to do different things within the same academy. We need some scholars to reach out and connect the Brazilian academy to the international scene. We need some to foster very strongly the domestic approaches. We need some to be able to write in local language, Portuguese. We need some to be able to write in regional language, often Spanish, and we need some to be able to write in global lingua franca English. And so there's no right approach. And the more that we homogenize on the idea of a right approach, the more that we end up with fragility of overdoing some things and underdoing others. And to me, one of the best examples of this is actually the Israeli Academy that has a very, very strong focus on like publishing in US law reviews. And so what do their scholars write on? They write on things that can travel. So you can't publish on Israeli law and Israeli institutions in American journals. No one would care in the American law reviews. You also are not particularly well suited to publishing on American law and American institutions. And so we see the Israeli scholars disproportionately go to things that travel across borders. So that's law and empirical approaches, legal philosophy, international law. Now, the international lawyers are very blessed to have Israeli international law scholars because they overproduce compared to any other country, and they really enrich our field. But that also comes at the cost of the domestic engagement with the domestic legal traditions and practice and bar in Israel in a way that's kind of problematic. My own feeling on these sort of things is there is good in all of them and there is bad in all of them, and that we need to kind of across our academies have a mix. So we need to create incentive systems that allow people to forge the path they want to forge so that at the end we get diversity. But the path that you forge, I think, should be about the one that speaks to you the most. And I hope that some people, it speaks to them to speak in one language more than another, or to one audience more than to another, but that we try to get diversity across the state and across the region rather than prioritizing a particular one.
Thank you once again, Professor Lucas Lima, and once again, Professor Anthea Roberts. Thanks for the fascinating answers you're providing us tonight or this morning. Well, we do have many questions, but I will have to focus on just a couple of them in order to let you go. So in my following question, I would like to discuss a little bit the role of regional institutions, regional organizations and institutions. Do you think regional organizations such as the European Union can contribute to a certain uniformity of international law studies for its state members due to the promotion of dialogue and massive exchange between universities? For example, through the Erasmus program. Do you think this regional influence could occasionally prevail over isolated national approaches to international law?
Yeah, definitely. I mean, there's a hugely strong European approach, and things like Erasmus, which bring students to go from one country to another, I think were intentionally designed to forge European identity and definitely forge contacts between European members. So I think that really has an impact. Interestingly, though, there's no European international law textbook right? So you could imagine a European international law textbook that spoke to the international but also focused on European institutions and also state practice from around Europe. But we don't find one. You also don't find an Asian international law textbook or a Latin American international law textbook. And so we kind of end up having a lot of exchange on certain areas. So European Court of Human Rights has its whole own body of scholars and practitioners who are densely connected with each other, but often less connected with other parts. And so I think sometimes when you've got lots of different centres, you end up losing a centre for the whole field. So I think we can see that happening with some of the Europeanization of international law in Europe. One of the other things I really notice about Europe in this is that it's very common, if I present on this, for them to sort of laugh at the American approach and even to some extent the British approach as being so parochial, so English language, so common law, kind of like, don't they know that you need to be international? We as continental Europeans, of course, know this because of our different languages and our different crossing borders and different sort of civil and common law traditions. But I find that even though they are very, very aware of their sort of cosmopolitanism in that way, I find, for example, the level of understanding of Latin America to be and Africa to be low in Europe, but I find the understanding of Asia to be incredibly low. And I remember having this reaction in a German institution where the person was like, well, of course, we know the importance of different legal traditions and different languages. And I was like, there was a recent study of history professors in Germany that found something like 95% of them did German history or European history. And of the 5% that did anything else, I think like 75% of them did American history. And so that left like about 1.25% that did the rest of the world. I mean, if you want to have any understanding of the way the world is changing and what's likely to happen, you've blinded yourself to that when you have that sort of approach. And so I think there can also be interesting ways in which in certain regions we think that we're very cosmopolitan, but we only look in one direction and we don't look in other sorts of directions. I guess the one other thing I'd say about regional approaches is there's always that thing between the Latin American Court of Human Rights and the European Court of Human Rights. I think you see in some of these some real power asymmetries where the Latin American ones will often reference the Europeans in a way that the Europeans won't reference the Latin Americans, and that the European one is considered to be kind of the international one and the Latin American one considered to be the regional one. So I think you see some of those kind of instincts coming out and some of that sort of hegemony and counter-hegemonic forces playing out whenever you see these regional developments happen.
Mm-hmm. Oh, excellent. That was one of the questions that I had as well. Regarding the influence of the European court in the inter-American system and vice versa. Yeah. Now, I have recently met the author of one of the case books, recently before the pandemic, that you cite, and he mentioned that he was included in some foreign cases as a result of the criticism he got in your book. So I believe that the wide audience that your book has had will provide, it's my impression that it will provide a major change in the choices that some authors make, especially in English-speaking countries. Do you agree with that? Or do you believe that inertia is an obstacle, perhaps too powerful?
So I believe both, as with most of these sort of things. So I think we'll continue to see many of these trends play out for a long time. That being said, I think you often have wake-up calls that encourage people to move in various ways. And I think a whole variety of things are giving us those wake-up calls at the moment. So I think we will see movement. Will we ever see full movement? No, I doubt it. But I think we will see some movement. I guess one of the strange things as a scholar is you often think of yourself as commenting on fields. I guess as I've gone on in my career, it's become a bit more apparent to me that sometimes when you comment on fields, you also affect fields. And that's something I'm getting more aware of as I grow up in a field. And so it can be easy to overestimate influence. It can also be easy to underestimate influence. And so at the moment, I just try to not estimate influence.
Can we finish with one question from the audience?
Yes, absolutely.
So the question comes from a student from UFMG, Fernando Porto de Sá. And the question is, what can we do so that lawyers with different backgrounds engage in meaningful dialogue beyond just exposing themselves on a surface level with other approaches?
Make friends. Seriously, make friends. So I think one of the things that I really take from my graduate studies days was the sort of wide community of international lawyers from different states that I met. I studied at that point in the US, but with a very international cohort. And it was really clear to me at the time that some of the people I was studying with had very different approaches on some of these international law issues. And I remember one of them who had a reaction to one of the cases that you actually put up, actually. And this was an Israeli friend, and we were talking about the wall opinion in the occupied territories. And I remember he had a certain reaction to it. And my reaction to him was like, I think you're profoundly influenced by the country that you've come from in the way that you interpret this case. And he said to me, I think you're profoundly influenced by the fact that you come from a big country that hasn't sort of had wars on its territories in the way that you come to this. And I thought, there's probably a lot of truth in that. So, and many of these friends that I made as students now occupy actually quite significant positions in different academies and also in different governments. And there is something about trying to know international law through others' eyes, through a friendship, and through finding what you have in common with each other, but having these sorts of exchanges that I think is very, very meaningful. So I would say try and look for situations where you can get beyond the books and you can find the people that are behind the books and behind their approaches, and try to have conversations where you sort of surface your different understandings and approaches and try to learn.
Well, Professor Roberts, thank you very much for engaging in this very relevant conversation with the Brazilian audience. I also would like to thank my great friends and discussants, Michele and Lucas Lima. And finally, many thanks to Henrique Schoer for his diplomatic help, which made this talk possible. Mariana Ferola, Mariana Ribeiro, Isabela Matos, Fernanda Carvalho, Mariana Ferreira, Bárbara Solero, Luciana Fernandes, Bruno Biazatti, and Tanaya Maia for all their help. I thank all of you who were here with us tonight, and I look forward to meeting Professor Roberts in person here in Brazil.
I hope so. Thank you very much for the invitation, and also for just how incredibly substantive your engagement has been. I'm deeply honored that you would do the kind of study that you've done, and I look forward to reading it when it's out.
Excellent. We will look for your comments. We will anxiously wait for your comments and reaction then. Thank you very much.
Thank you.
Bye. Thank you.
Bye-bye.